Hello, hello, hello. Good morning, everybody. It's good to see you all here today. Welcome as you're coming into the room. This is a recorded session, but please feel free to use the chat and introduce yourselves. When you introduce yourself, please feel free to offer your name, your agency, where you are calling in from today. And I believe there are captions. If you would like to have the captions as well, you can click so at the bottom of your screen. But to get us started today, let me introduce myself. My name is Kimberly Richards with Justice System Partners, and we are hosting today's Pet Network webinar about reframing failure to appear, challenging the harmful use of bench warrants. And so to kick us off, I would like to give a little backstory about what the Pet Network is. As you all know, right, jails have become warehouses for people who are struggling financially, people who may lack housing, people who may be challenged with mental illnesses or struggling with using substances. And so a lot of times these jails reflect America's long history of racism, but are misused and are overused in ways that are damaging to families, devastating to communities, and ultimately lead to more crime. And so in 2015, and launched by the MacArthur Foundation, the Safety and Justice Challenger, the SJC, aims to change the way America thinks about and uses jails. And so the foundation has invested in over 40 local criminal justice systems across the country that are working to improve public safety, eliminate racial and ethnic disparities, promote stronger and healthier communities, and reduce the financial costs associated with incarceration. The Safety and Justice Challenge invests in locally developed equity-based solutions that take a balanced approach to protecting public safety. And the goal is to support policies and practices that will safely reduce jail populations by 50% across all SJC jurisdictions 2025. With that, and as a part of the SJC is the Pretrial Equity Transformation Network, and part of that being the webinar series. And so the PET Network is a peer learning network, and the goal is to elevate the SJC sites engaging in meaningful front-end transformation work and provide opportunities for other sites and other jurisdictions to learn from this work. And so this webinar series brings together technical experts, people with lived experience, and practitioners to discuss new and promising programs, practices, and share lessons learned. So for our conversation today, we are going to begin by unpacking the evidence behind bench warrant effectiveness. From there, we will transition to a facilitated discussion with our awesome panelists, which you will hear from and be introduced to a little later on. And then we'll open up the floor for some Q&A. We want to make sure that we hear your questions, hear your comments. And so please feel free to submit your questions to the presenters. And we will make sure to elevate them once we get to the Q&A portion and include them in our conversation today. But we really want to make sure to hear from you. Your experience, your insight, your questions matter. So please engage with us. And then with that, I'm going to turn it over to my colleague, Shannon Magnuson from Justice System Partners to unpack the evidence behind bench warrants. So Shannon, I will turn it over to you. And you're muted.
Thanks, Kimberly. I so appreciate being here. I'm excited to talk about this and kind of get us started. What I'm going to share today is really about kind of the evidence related to bench warrants and kind of the harms that come with those bench warrants. But as part of that, we're going to also talk about the ways in which we might not be thinking about bench warrants all the way. I'm going to share a lot of information that I know that you already know, but we're going to really think about it and perhaps in a different way. And so the main thing that you can take away from anything that I'm going to say today is this: that bench warrants are a false and expensive promise of court appearance. That's really it. We know that there are two kind of main pathways that people have when they're coming into the system and as they're going through case processing. The first really is that folks are arrested and they're booked into jail, and that they may maintain or stay and detained in pretrial throughout the length of their case processing. And while they're there, they'll attend lots of different court hearings, and they will appear for those court hearings because they're being transported to court. We also recognize for a vast majority of people, and probably perhaps more people than those that are detained, that they're being arrested and that they're actually being released pretrial. And as part of this release agreement, that they also have to show for those court hearings until sentencing. In some jurisdictions, though, we recognize that pretrial monitoring exists, and that in addition to having court hearing obligations, that folks will also have pretrial monitoring obligations. So that could look like calling in, that could look like actually going to visit their pretrial officer in person or at the court, or it could look like the pretrial officer coming to them. And what we're really talking about today is this group of people that are being released pretrial. We recognize that there are actually no national averages about the number of hearings that people have to attend, but by and large, we understand that those hearings include arraignment, status hearings for discovery, maybe motions to suppress hearings, plea hearings, or sentencing hearings, and sentencing hearings. We also recognize that by and large, people make it to court. That's great news. But we also recognize that some people don't make it to court. The research that we've done here and others have done, like Ideas 42, says that there are kind of three main reasons that people don't make it to court. We've done this research in Lake County, so excited to have someone here from Lake County to talk about this as well. And what we did was we talked to people who were in the Lake County jail exclusively for a bench warrant, not because they had been picked up for a new crime, exclusively because they did not appear in court. And we asked them, what was going on for you that day? And what we learned was that there were three main reasons why people didn't show up to court. And they had life responsibilities, childcare, caregiving, employment issues, wages, or that they didn't want to give up their wages, rather. They had other court obligations, so they weren't able to make it to their criminal case because they were actually in family court or in divorce court, that they were unmedicated, and because of that, they just had other challenges getting to court. They were hospitalized. A lot of this was kind of at the end of COVID that we talked to people. They were navigating houselessness, or that they forgot. Folks also talked about these logistical challenges, like they didn't have access to a car, they were out of favors from friends to get a ride. In settings where there was virtual, in Lake County in particular, they did virtual court, and so the virtual passport, the password wasn't working, or they were in the wrong virtual docket room. And so ultimately, they were not there, and a bench warrant was issued. Other folks said that really they had experienced racism or ableism or stigma and part of previous experiences. And so they just were overwhelmed emotionally about getting to court, that they felt that court actors were unhelpful, or that there was too much information, not enough information, conflicting information. And a lot of times folks said that they weren't just challenged by one of these domains, that a lot of this was happening all at once for them. And whether we like these reasons or we think that they're good reasons or not to get to court, the bottom line is these are the things that people are challenged with to get to court. But in some cases, we hear this narrative that folks choose not to come to court. And I think there's a real complication with using the word. And we've decided that really what we're thinking about is folks are making survivalist decisions, really. And so somebody that we talked to had said, I'm homeless, and as part of the agreement with the local shelter, they drop us off at the community library and they would tell us to stay there till 2:30 p.m. If I leave, the shelter won't guarantee my place for the evening. He's saying if I left the library to go to court, where court is happening in the afternoon, I wouldn't have a place to live. I didn't want to jeopardize my shelter for that evening by leaving the library. Lake County is physically located just north of Chicago. And while we've met people generally in summer, what is true about people who are navigating spaces in Lake County and otherwise is that we're talking about times where it gets really cold, or I'm in Texas in places where it gets really hot. And we have to also be thinking about the ways in which choice matters here. Choice isn't really what we're describing, is that people are prioritizing oftentimes their basic needs over going to court. And what we also know, though, is that even if people have a history of appearing in court successfully, that missing one court date can actually end in a bench warrant. And when that happens, folks go back to jail, they're arrested, and they come back through, and there's another decision about whether they're released. And what we learned from folks in the Lake County Jail was that they were navigating these experiences on the day that they miss court, but that they really are navigating these experiences potentially over and over again. And really, there's a smaller number of people where these are consistent challenges. And as they miss court again, they have another bench warrant, and they miss court again, they have another bench warrant. And this cycle continues for them until they're sentenced. But we recognize also that that's the journey for some. But for another portion of people, they actually might be having multiple cases. And when they are having multiple cases, that they're making these calculations across all of these hearings that they have. And in particularly in jurisdictions that are not tracking cases together, or for people that are experiencing cases in multiple jurisdictions, so across county lines or across state lines where people are living pretty close to the state line, what we're starting to notice is that people are then navigating one set of court hearings, another set of court hearings, and that they're having a hard time managing all of these court hearings. And so they're getting to some, they're not getting to others, and they're finding themselves navigating potentially in and out of jail during this entire time, even when they're actually attending more hearings than they're missing. And what we recognize then is that there are large impacts because of these bench warrants, including the financial cost of folks. And so what ultimately happens is that somebody gets picked up on a bench warrant for not appearing in court. They come back through. When they come back through, effectively have another release hearing. At that point in time, there might be an increase in bail or bail set in which it hadn't been set before. And so let's say in this example, on the second version, that bail is set at 500 and that there's an ability to only pay 10%. And so now this person is paid an additional $50 to get out. They come back again. Of course, we understand that bail is set again for release. And at this point in time, we're setting bail higher than we were previously. What is true about this is that there is a false narrative that bail and increasing bail amounts are going to be the reason somebody comes back to court. But the reality is that research does not support the fact that higher bail means court attendance. And so effectively, we are just making people pay more as they're navigating more. And the people that are paying more are generally the people that have the least. What is also true about the impact of these bench warrants is that when people come in, they come through, and if they don't have a bench warrant, particularly in the last 2 years, they have fewer points, so to speak, on a pretrial tool. So many of you might be using something like the PSA or the VPRE, where part of the total score of what people will get is in large part determined by their history of missed court appearances. And so ultimately, if somebody comes back through, they now have one additional point in the FTA item on their PSA or the VPRE score. They come back again, now they're at 2+ FTAs in the last 2 years. What this functionally means, though, is that these additional FTAs in the same case is actually bumping up somebody's monitoring because they're getting a higher PSA score or a higher VPRE score. And so this is potentially adding to the obligation of what people are having to navigate as a result of having the FTA bench warrant. And to complicate matters, some jurisdictions also issue failure to comply warrants. So these are warrants that are for folks that are not complying with pretrial orders. So effectively now there's a new opportunity to bring people back to jail for, again, things that are not new crimes, that are really about their lack of resources to fulfill some of these obligations. And ultimately, what we're seeing is happening is really that people who have a lot of these bench warrants ultimately remain detained, that they were originally in that first pathway of release, but they over time during case processing moved to that second pathway. And that might be because we've decided they no longer can make it to court and we need to detain them, or because we've decided to issue bails that are so high that we've effectively created pretrial detention. And what we know about this is that folks that remain detained are more likely to receive a conviction. They're more likely to receive a period of incarceration, and they're more likely to receive longer sentences. And so it begs us to ask then, are the punishments that we're doling out, or the sentences that we're doling out, are they entirely related to the charges, or are they in part then related to the case processing experience, and therefore related to things that are not about their criminal behavior and rather about their lack of resources and inability to get to appointments on time? But the biggest thing here, though, is that emerging research out of the University of Pennsylvania related to work that's been done in Philly is showing that police, witnesses, victims, and lawyers miss court more often than defendants. And yet it's only defendants that are punished for missing court. There are better ways that we can do this, for sure. And so we understand that there are lots of research about different things, but those things cost money. And those things include automated court reminder systems. There is overwhelming research to suggest that court reminder systems are really effective in helping people get to court. And certainly when you are able to offer them in multiple languages, particularly if you have monolingual speakers in your jurisdiction, that's even more effective. We understand that targeted support via pretrial support agencies is really helpful, particularly when we're giving them the support that is related to why they're not missing court. So ride vouchers or ride share credits, right? If we're thinking about the ways in which we might be finding them housing or even doing shelter court that exists in some spaces. And then certainly there's research that's saying that peer navigation programs are really helpful. But these types of strategies cost a lot of money. And the reality is that there's so many other strategies that we could be using that are really no to low cost strategies. And that's really thinking about what's the total number of hearings that we're asking people to come to, and how can we reduce those hearings? Can we create a global waiver of personal appearance on the ones that we don't require anymore? Can we start to be thinking about people's availability to even get to the court hearings that we've assigned? Can we think about creating open or makeup dockets where people can walk in and kind of have a redo of what they missed? Can we be thinking about tracking open cases more thoughtfully together and even kind of doing more global resolutions as a result? Can we think about how to use virtual technologies better to help people get to court? And then importantly, treat them equal to in-person appearances. What we learned in our Lake County study is that while people recognize that virtual technology or a virtual appearance was allowed by the court and would be better for them, they often would say that they would avoid the virtual option and come in person, even when it would not behoove them to do so, because they felt that judges treated them better when they came in person. That judges were much more punitive to people when they appeared virtually. And so thinking about how do we use or expand virtual technologies, but then make sure we're treating them as equal to in-person appearances. How can we leverage the role of defense counsel? And how can we be thinking about citation in lieu of arrest warrants or summons instead of bench warrants? So those are all of the strategies that are really no to low cost and really take just courage to implement them. I'm excited to share kind of these ideas and talk about these ideas with our esteemed panelists who have a lot to say and have some other options or other strategies for you as well. With that, I'm going to invite them to join us. Hello, hello. How are you all?
Great.
Doing well.
Yeah, doing well. Good to see you. Good to see you all. Good to see you, Shannon. I really appreciated that presentation.
Appreciate you. Well, before we kind of get into the nitty-gritty of the questions that I have for you all, I want to take a moment and let you introduce yourselves. So with that, Mano, do you want to kind of start us off?
Sure. Good morning or good afternoon, everyone. I'm Mano Raju, the elected public defender for San Francisco. And I'll kick it over to Eric. 'cause he's next on my screen.
Good afternoon, everyone. Thanks for being here. My name is Eric Reinhardt. I'm the elected state's attorney, a prosecutor in Lake County, which Shannon mentioned. And I will send it over to Judge Trosh.
Good afternoon, everyone. I'm Elizabeth Trosh. I'm a district court judge in Charlotte, Mecklenburg County, North Carolina. Former chief judge here for 4 years. And I look forward to talking with you about this important burden on our system and on probably some of the most vulnerable individuals in our communities. Oh, and I need to kick it over to Elaine.
Hi, everybody. Happy Thursday. I'm Elaine Borikov. I'm the president of the Justice Management Institute. We are a site coordinator for the Safety and Justice Challenge. And we also provide TA to all the SJC sites on case processing, of which FTAs really does fall into that category. So I look forward to hearing from all the panelists and hearing from you guys on the webinar.
Well, I appreciate you all being here. I feel like you are all really, rock stars about people who are thinking about this, being really thoughtful about this, and really encouraging us all to do better. And so with that, I kind of just wanted to start with, Judge Trosh, I know you've done a lot of work on bench warrants, but I wanted to ask, just to kick us off, like, why are we so prone to rely on bench warrants as the tool? Like, why do we like it so much?
Because it's easy. I think that's the reality. Like it's just so much easier, especially I think in our misdemeanor and even traffic courts that tend to be higher volume, to just set those cases where defendants fail to appear aside and say, issue the order for arrest. So you can focus your attention on the cases, that are in front of you and have the witnesses and the defendants present and ready, for a hearing, and doing just about everything else that would be an alternative to issuing an order for arrest for failure to appear takes time and it takes attention. And it's easier. And I think that we ascribe, as you said earlier, a lot of intent and willfulness to the defendant's absence. That when even you just stop to look at a case, oftentimes it becomes readily apparent that maybe that intent and willfulness is not there. But I honestly think it's easy. It's what we've always done. I think that's the answer.
I love that the easiest answer is simply that it's easy, right? That I think that's it. And I think it's the thing that we have to challenge ourselves to say is that should we be doing it simply because it's easy? And I think your point is well heard that these bench warrants are used because we also have this idea of intent or willfulness. And we're even starting to see the concept of willfulness in legislation that's being passed. Mm-hmm. And really, when we're starting to think about why are people missing court, there's not a lot of willfulness. And when there is a bit of a choice, that choice is not made in a vacuum, right? It's made in context to basic needs. It's made in context to choosing between hourly wages and getting to court, or losing hourly wages and getting to court. And those don't really seem like choices to me, right? In the grand scheme of things. And so I think that this narrative that we prescribe to absence is really important to acknowledge. And so I wonder, Mano, for you, how do you see bench warrants impacting your clients? Like, do you feel like it feels right that they're making survivalist decisions, or there's not a lot of intent and willfulness about why they're not showing up anyway?
Yeah, I agree with, I really appreciate you breaking down to life responsibilities, logistical challenges, and institutional experiences as reasons that people fail to appear. I was just talking to a colleague who was explaining that literally their client was having a mental health breakdown. The social worker was literally seeing that, telling him he's having a breakdown, he can't make it to court today, communicating that to the defense attorney telling the judge that. So in touch with institutional players, really explaining what's happening in this moment. And the judge not caring. Now, there are some judges who would take that into account, but that happens so frequently that there are, you know, real, as you said, life choices. Like, I don't want to lose my job. I don't want to lose my shelter, or I couldn't get childcare, or a lot of, especially low-income people of color, are living with extended family. I have to take grandmother to the hospital. There are life events, and the life events happen much more frequently for our clients, which is often sometimes the reason that they're in the system to begin with. So I think it's very crucial that we start, you know, making that distinction. I believe Illinois might be one of the few states that has that distinction between a willful, intentional failure to appear and versus a life experience generating that. And I think the more we can just make people aware of that, the better. But the impact is, as you said, it really distorts outcomes. There's a lot of, when we say we, I think that for the prosecutor it's easier. Sometimes for the judge it's easier. I think not thankful we have a judge and a prosecutor here who think differently, but for a lot of people, they know it's easier if that prosecutor can say issue a bench warrant and the judge does it. They know the next time what can they do? They can offer, you can get out if you just plead guilty. And that's a lot easier than doing a contested hearing, dealing with an aggressive attorney who's going to take the case to trial, who's going to beat some counts, things like that. So for them, it becomes easier to generate that plea, basically generate a coercive plea bargain situation. And you're right, it will have nothing to do with whether the elements can be proven. It'll have nothing to do with whether there was a constitutional Fourth Amendment violation that we want to litigate. It'll have nothing to do with any of that. It'll have to do with someone choosing between being in a cage and then being out with their family and maybe the responsibilities they have with their family. That's what's going to determine the guilty plea, not anything having to do with the elements of the crime actually being proven.
Yeah, I mean, I think this is a real thing that we have to reckon with, is that it is in part perhaps the behavior of case processing that is determining much more about their outcomes rather than the initial charges. And I think that is something that we have to kind of reckon with. One of the things that you mentioned, Mano, is the idea that, you know, Illinois is, they've moved away from cash bail, and that they have created in their legislation guidelines about thinking about preventative detention more intentionally, and then thinking about failure to appear, thinking about it more about willful failure to appear. And we've kind of discussed here that willful failure to appear is also really challenging and complex too. But I'm curious, Eric, you know, as we start to see more states move away from cash bail and only certain types being eligible for detention, like, then what do you see of the role of bench warrants, or how do you see bench warrants potentially increasing in these spaces that are no longer using cash bail?
Well, yes, and I really agree with everything the public defender and the judge have said so far, Shannon, and your points, particularly about judges, not judges, but police and lawyers and witnesses missing court more. That's very powerful to me. Yeah, I think that there can be a reaction to potentially criminal justice reform that is legislatively imposed, where judges could have that reaction. I hope that's not happening. They may feel that the person should have already been in custody. In Illinois, I was very proud to be an elected prosecutor who supported the bail reform. And one of the things that I thought was very important was that the control it gave back to the prosecutors, who may know the case. They may know lots of things that can't always be conveyed to a judge. But at least in Illinois, prosecutors have control over whether or not to even trigger that initial detention decision. And I think that that's very important. I think that elected prosecutors and obviously assistants under an elected prosecutor should be making that transparent sort of good government decision, and to judge prosecutors on whether we're getting it right, to either trigger the detention decision by the judge or the detention analysis, as opposed to not doing that. And so, first of all, that's where we are in Illinois. It has to be a prosecutor who even starts that. A reaction to that could be that an individual who's not detained because of the legislative rules or because of a decision that a prosecutor makes, the decision that a judge could make is say, well, I think that Johnny should have always been in custody from the moment of the arrest, so now I'm going to issue more bench warrants the second that he makes a mistake makes a mistake or doesn't come to court. So we definitely don't want to see that. I think it's very important, and I loved what the judge said about because it's easy. I think it's very important to confront the psychology of why these things are happening. And they are obviously a public defender, Raju, they are on our side of the bill. They are on the judges and prosecutors side of the bill. Your team is always going to be objecting to a bench warrant appropriately. I think we have to think about the psychology of it. I want to say two quick things. I love what you said about, we are sort of assuming that it's this willful decision. And when we say it's willful, we are sort of saying it's moral, right? We are saying that you are making a decision not to come to court and it's willful and that's a problem. One of the things that I think people have appreciated that I've added to this is we have to get a little bit out of this idea that it is true that this case might be the most important thing in someone's life. Let's accept that, actually. And by the way, with concerns about jobs and kids, that may not even be true in a misdemeanor, and maybe some low felonies. Taking aside whether the case is the most important thing in the defendant's life, I want to ask the question, is this court date the most important thing in the defendant's life? And that's a big difference, right? If you tell me my trial is tomorrow, that's one thing. If you tell me that my date is tomorrow to see whether the police finally tendered that 911 tape that we've been asking for 3 court dates, that may not be as important to me as meeting the plumber, right? We have to think about what each of these court dates are separate from the morality and the morality play of why did Eric miss court yesterday? Well, does it matter because we are still missing that damn 911 call? So I think breaking it into why did we have a court date is an important part of the conversation. And then the only other last thing I'll say, and the judge made me think of this, when we say it's the easiest thing to do, I think that there is a real, with prosecutors and judges, a real psychological concern. And I think we have to confront this, that if we don't issue bench warrants, dockets will build because we are not resolving court. So I think it is a big decision that a thing that I think us as reformers have to confront. Is it true that if we have less bench warrants, dockets will build? I don't know the answer to that. I'm not proposing that the answer is please to get out. I don't mean that. I appreciate what the public defender said about that. I don't mean that. I do think we should have a systemic reaction to a well-meaning, good faith judge who says, Eric, I got to issue bench warrants or else my docket's filled. I think we should divert first. I think we should have those open cases, those open dates where you can come in and kind of make up for it, Judge. Well, let's do one on July 20th and make up some of your concerns about the docket. I think we're stronger when we deal with the real psychological reasons and maybe a good reason when judges say, hey, I get it, but if my docket builds, that causes other problems.
Eric, I appreciate each of these kind of laying out, and I think that's right. I feel like the conversation of this could be a real thing, that the dockets could be building. Here's why the bottom line is that bench warrants are a false promise of attendance, is that bench warrant requires either passive contact with police or intentional contact by police, both of which, particularly in the passive place, which is generally how we're actually executing bench warrants, could take years or weeks. So even in the concept of like, I'm going to issue it because it might build, the docket might build, it might still take weeks or months or years, dare I say. I think Elaine has some comments about that, years to actually execute that bench warrant and bring it back. And so I think that's then.
But many judges take that off of, and many counting rules from Supreme Courts take that off of the docket size. When the warrant is issued, there are a lot of systems that say that's no longer on your docket. Good job, judge.
Yes. And I think Elaine has something to add there too about, what does it mean then to respond to this? So Elaine, I think this is the time, like when a judge says, I have to issue these bench warrants, case processing metrics are a way that I am measured. Kind of what is the response to that then?
Well, I think, and Eric, your point is right. Once it comes off your docket, right? It's like, okay, then it's not part of my caseload. The reality is that, unless you're tracking these cases separately, you're not, as a judge, you're not working a case in which a bench warrant's been issued until that person comes back before your court. And so keeping it on the active pending caseload, gives a false narrative, right? It shows you have all these cases when reality 10, 15, 20% of them are completely inactive. So one of the things that we really stress for people is you don't take it off your docket, but you create a separate metric that is called inactive pending. And that inactive pending shows you how many cases are out there for failure to appear with a bench warrant. It could also include competency. I mean, this is another one of these types of cases where, competency, there's a little more judicial work going on. But the reality is, there are long, long periods of time before which you're going to touch this case again, if ever. And then there's the other question of, at what point does it become inactive? If you're not tracking this, how long does it take before someone who has a bench warrant comes back on average to your court? To your point of active versus passive, do you take that off the minute the bench warrant's issued and put on to an inactive pending caseload? Do you wait 30 days? Do you wait a year? We don't have standards for that, but I think it's part of the conversation that, these cases, if they're not being actively worked, really need to be thought about as something different, but not ignored. Meaning, don't just take it off the docket, it doesn't exist. It's still an active case, and you have to know how many are out there, and you have to be able to understand how long it takes before someone comes back, if they come back. And I think those are really important things that we don't necessarily do well in all courts around the country, in part because of state AOC reporting requirements, but also just the capacity within some of our courts. Some courts do a great job of this, but just how we count cases and how we manage our dockets in state and local courts.
I appreciate that. And I think that's right. And I think also thinking then, and I know we'll get to this probably here shortly, is that, if we're using some alternative strategy, not a bench warrant, how then can we also think about those cases moving to this inactive pending as well? But one thing I want to come back to, Eric, that you said was that you mentioned, that we have to really be thinking about, even if we assume that court should be the most important thing in someone's life, even if we assume that we have to really even break it down to the hearing level. And then at the hearing level, it might not be the most important thing today or this week. And so to that end, then, how kind of does the sheer volume of hearings play a role in why we're seeing people miss court? And I wonder for you, Eric, then how do we rethink this? Like, what do we do? What appearances are mandatory for us?
Right. Well, I know Judge Trosh talked a little bit about this in another presentation about, well, would we issue a warrant when a victim wasn't present or an officer wasn't present at a trial? I've seen judges go both ways on that a lot. Before I was state's attorney, I was defense attorney for 17 years in the same county, and so all the time you would say for your client, well, why are we issuing a warrant when the victim or the police officer isn't here? We weren't going to do this trial anyway. And so I think that's really, and certainly what the judge talked about that. I think that's really important as a starting point. We can have multiple dates. We can have a discovery date. We can have a discovery date on July 15th and a trial date on August 15th. You can do the advisals that you can be tried in your absence if you're not here on August 15th. And I assume the lawyers will figure out all the discovery between now and August 15th. I tend to think that works. I think judges and prosecutors and maybe defense attorneys even think that multiple court dates is where you would resolve a plea, that you would do the plea on one of those intervening dates. Nothing wrong with that, but I think we can do better in saying, well, if we're going to do a plea date, you're going to do it by July 30th. Trial date is still August 15th. Maybe I'll see you on July 30th, but you're advised that you will be tried in your absence if you're not here on August 15th, and then August 15th potentially becomes the warrant date. I think there should be those intermediate dates. I assume that's how a lot of federal court works. I have not practiced in federal court. I don't know if anyone else has. I assume that's how federal court works, but then I have defense attorney friends who say, well, Eric, meaningful things can happen, and you are excluding the defendant from some of those conversations, and maybe the public defender feels that way even from what I said. The problem with that is that I have judges who are going to issue a warrant when you don't show up to that date. So I defer to the defense bar whether or not they want to create these dates. I have a very kind of specific view on it as a former defense attorney, but other defense attorneys actually will disagree with me on this.
Well, can I jump in, Shannon?
Please.
Yeah. Well, I think that first of all, I really appreciate State's Attorney Reinhardt's distinction between the case being the most important thing in their life and the court date. I think that's really significant. I think the more we can reframe some of the thinking about this, the more we can start shifting the culture. But I think we also have to look at benchmarks within the overall context of court culture. There's often a hostility when a client is out of custody to proceeding on what's called a no time waiver. So the reality is, if the client was released, it's probably not as serious a case. It doesn't take as much to work up. So I would routinely, in my practice, when I was a line attorney, set cases, even if the client was released, give me the preliminary hearing within the 10 days. Why? Because it takes less time for me to prep the case. It's less likely that the client's going to forget about the date or have intervening events, less likely they're going to pick up something else. So if you're concerned about case processing, then why are you hostile to me proceeding on a no time waiver? I can get to trial or disposition faster. There's less intervening court dates, but there's sort of this notion, I've let the client out. So now expectation, the defense bar should waive time now, which then drags everything maybe out for you, whether it's a trial or a dispo or a diversion. Why can't we have that happen quickly? So first, I think we have to change the hostility from sometimes the bench or prosecutors to let's proceed on it. Just because the client's out of custody does not mean we shouldn't be proceeding on a speedy time waiver, because it's less court dates. The case will either go to trial or resolve or get diverted quicker. Another thing that we should factor in, though, is, as you pointed out earlier, when someone fails to appear, that may show up on a pre-trial assessment later on. Why don't we talk about all the times the client did appear? And I just told one of my colleagues, is next time that judge says there was a failure to appear, I want you to put on the record how many times that client actually appeared. If they appeared 9 out of 10 times, that's an A. Okay, that's really good. So why aren't we factoring that in? And why don't we saying the percentage of times, as opposed to there were 3 failures to appear? Why don't we say they appeared 90% of the time? And I think to put that in, that's a much better predictor than just looking at failures to appear.
I think that's,
Yeah, go ahead.
well, I think that's the issue, is that, you know, like what I said earlier, we issue the bench run because it's the easy thing to do. And here in Charlotte several years ago, we started looking at the impact of those bench warrants for failure to appear on our jail population, and just the sheer number of people who were sitting in jail, oftentimes for very long periods of time, on low bonds that were set on an order for arrest that went out the door without any real reflection on what's going on here. Does this seem like the right thing to do? Because they couldn't post the bond, right? So now they're sitting in jail because they're basically poor. They can't afford to post the bond on charges that, you know, they failed to appear on. So we started looking more closely at what's going on here. And the first step of that was actually just doing case reviews of file reviews of a month's worth of cases that orders for arrest were issued. And what I found was that on a huge percentage of those cases, a couple of things were happening. Either they were sort of administrative kinds of settings, like what Mr. Reinhardt was talking about, where it's sort of like, oh, do we have the evidence? Have we gotten all the discovery? Do we have what we need to even make a prosecutorial case decision on, do I think I can proceed on this charge? Am I going to do something else? And the defendant, as Mr. Raju said, had appeared several times over months and just happened to miss this one time. And then the other big category were cases where the state's witnesses weren't there. And, oh shoot, I froze on my side. Did I freeze for you guys?
No, you're good.
Okay. The state's witnesses weren't there. So the state wasn't going to be able to proceed, but for some reason, this defendant is being is out in the community facing fear of arrest for failing to appear, and we didn't take a closer look at whether the case would proceed. And on some of those cases where the state's witness had not appeared, they'd been served with subpoena and did not appear. And we should have been questioning what, if anything, the state was ever going to be able to do to get their witnesses to court and proceed. So I do think the context matters. And it's important to review the context and the history of the case to make a determination about what is an appropriate response under these circumstances.
I appreciate that. And I think, I think you are pointing out in real time of a real thing that you acknowledge that that folks were sitting in jail when they had actually appeared more often than they had not appeared, right? That even a C is passing, right? 70% of the time is still a good, right? We like that. C's get degrees. And even then, that would not be enough, right? And I think your point too about saying, your lived experience in Mecklenburg points to the research that UPenn did that says other folks are appearing more often, but it's only the defendant that's getting punished here for the non-appearance. And really understanding all of the things that are happening there in the background. And I think that Mano's commentary about like, why aren't we using the totality of someone's success before issuing these warrants or doing anything in response, I think is really spot on. And one thing that comes up then for me is maybe being more thoughtful about scheduling and how then can we make sure that scheduling is done and so where it's accommodating the attorneys, it's accommodating witnesses should there be any, but it's also accommodating the defendant. And so Elaine, I wonder, I know you have done a lot of work at JMI related to scheduling, and so kind of what is your experience kind of helping courts understand how to do this work?
Yeah, and I think this is a really important point, right? There are things that individual actors can do within the system to address this issue, and then there are sort of systemic things that the courtroom work group can do. And one of the things that we really talk about with courts, prosecutors, and public defenders are the use of scheduling orders. And historically, scheduling orders are used to benefit the professionals in the room, right? We set the schedule based on when Mano has to be in court or when Eric has to be in court. But we don't often consider what the officer's schedule is, what the victim's schedule is, what witness schedules are, and more importantly, what the defendant's schedule is. And so we've not seen this in practice yet, but we are encouraging the courts that we're working with to take that time when they're putting together the scheduling order to do it with the defendant present, to do it with other parties present, to make sure that everybody agrees that this is a court date we can attend. And I think, Judge Trosh or Manu or Eric are probably going to talk about this later. In addition, does this even have to be an event that the defendant needs to be there for? Because as we've said repeatedly during this call, there are multiple times when the defendant shows up, but the witness doesn't show up, or it's a procedural matter and discovery hasn't been exchanged. And so, are these really necessary events for the defendant? So I think that's just something to think about. Not everybody uses scheduling orders, but they are a really powerful tool for judges to manage their docket, for prosecutors and defense to be able to manage their court appearances and their staff allocation. But we also have to think about the other parties and how these scheduling orders can benefit them too and reduce the barriers to appearance.
I appreciate that. I wonder, Eric, you've commented a lot about which hearings are even useful for people to be at. And so I wonder, for you, what would you see in your court? Where would you prefer people to show up, and where does it not really, their actual appearance doesn't matter as much?
Well, I love what Elaine said, and I don't even this is really important to me, and I wrote down scheduling orders because I think we should move into that. I mean, I do think it's important to acknowledge the crush of some of these calls. I don't know what everybody's individual experience with it is. As a former defense attorney, I'm not positive that I would even be able to quickly turn over and hear my guys say, Wednesdays are terrible for me. I mean, that's a simple request. Wednesdays are terrible for me. Daycare, get it over to a Thursday. Yes, 80% of the time, I hope I got that done, but that should be 100% of the time, right? And so defense attorneys always need to have that ready to go. I cannot do this on a Wednesday for my client. So I think those scheduling orders are really interesting and pre-planned out, and you could sit with your client early on while you're doing case preparation and begin to move into that process of, for the love of God, whatever you do, don't do Wednesdays. I think that these trial dates, I think these trial dates are critical, and these motion to suppress or motion to dismiss are, you know, are required dates. I think that those are the types of dates where you would really delay a case if a defendant didn't appear. Also, you know, with technology now, we got to say this, and I love the automated reporting system. We've seen a huge improvement in that in Lake County, and that's not because of me. That's because of the public defender advocating for it very hard. And so those automated reminder systems are great. But I mean, you know, people have cell phones at the bench. I hope that the defense attorneys are able to even say, well, Judge, my guy's not here yet, but I haven't heard back from my office, right? And so again, to have a culture of like, do we even know why the defendant's not here? There's a lot, I think a lot more can be done with that. But I think trials and critical motions are the dates where the warrants would come in. But really, all of us have to do better to eliminate unnecessary court dates. That's not a defense problem. That's not a prosecutor problem. That's not a judge problem. That's not a police problem. That's everybody's problem. Like, we cannot be having people come to court and have the anxiety of court and the trauma of court if literally nothing has happened. I tend to think that people think that when there are court dates, pleas are more likely. That may or may not be true. And so many of our times, our judges will require what's called a trial priority date, where it's the Thursday before the Monday. Okay, but I didn't miss my trial if I missed my trial priority date. So I think there's a lot to be done at the granular level of what are these dates really about.
I appreciate that. And I think you're right. It's about understanding what is going on for folks. And I think, you know, I've seen in some jurisdictions, unfortunately, where people are making it even to court, but they're not making it to pretrial monitoring for one reason or another, and they're getting failure to comply warrants. So they're actually coming back because they're not doing what they need to be doing for pretrial, but they are doing what they need to be doing for court. And so we have this again, this another moment that I think calls back to Eric's conversation about the larger thing about, yes, the case is perhaps the most important thing in someone's life, or could be, and they're treating it that way, but they're not treating this court hearing or pretrial monitoring thing as the most important, yet we're still seeing these returns. And so I wonder, you know, you're describing, Eric, a lot of this idea of like using the defense attorney's relationship to really rethink about how we do this work. And so I wonder, Manuel, for you, how do you see courts potentially leveraging the relationship that you have with clients to get them to court?
Yeah, I think, you know, well, first of all, I appreciate State's Attorney Reinhardt's point about from his defense attorney days about the importance of asking the client. And it could be a simple question, it's really about client empowerment. Just that question, like, let me know now if there are days that are particularly bad for you, and I'm going to try to avoid them. Because yes, we have to be aware of our own schedule as defense attorneys, and it's tough, but it makes it much tougher if our client bench warrants and then we're dealing with the client in custody, more clients in custody. It actually ends up being more challenging for the defense attorney too. So just that little time asking, if there are particular days that are bad for you, let me know, and I'm going to let the court know that. That pre-planning can make a big difference. But then also trusting us, like we are in touch with our clients. We're doing the best. The people practicing at the highest levels are the ones who spend a lot of time making sure the clients get to court. And it's an additional burden, but one of my colleagues does a really good job. I want your number. I also want an auntie's number. I want two numbers, and I'm going to, I need a call from you before the court date, letting me know you're going to come. And I need a couple other numbers that I'm going to call to make sure that happens, because avoiding that bench warrant is something that's going to avoid a plea to something that you don't want. For that, though, we need more time. I mean, throughout the country, we're dealing with issues of parity between prosecutors' offices and defense attorneys' times. And if we have way too many cases, it's tough to give that level of care and attention, which we should, to each case. And that's something that we want to do. So I think that's the first piece, is that the understanding of how more defense attorneys can actually overall help justice and public safety needs to be emphasized, so that we can put the work in to make sure, because if we're doing our job as well, our clients have trust for us because we're fighting for their best legal outcome. We're protecting their constitutional rights. They have Fifth Amendment protect. They can tell us anything. They can confide in us. So we are in a better place to ensure that clients show up to court if we're given the resources. And I think more social workers, more peer navigators, in public defender's office also help with that piece. So while we're working on the motion work, and if someone else can be working on those other pieces, making sure that person's navigating, whether it's pretrial services, getting to court, that could really, for a small percentage of the cost of all this additional expense that comes from bench warrants, really alleviate a lot of these issues.
Shannon,
I
could I
agree.
share something on this? The
Please.
where public defenders can or defense bar can be leveraged. In our jurisdiction, we've had a court notification system, but really low enrollment, partially because the system that the courts launched made enrollment, I think, cumbersome. Like if I had to enroll in that system to like get reminders from my doctor or my hairdresser, I wouldn't get reminders. So, and also we kind of realized that, so it was cumbersome. And so we really wanted to see what we could do to facilitate enrollment for defendants, just to really utilize this system more effectively and hopefully be proactive in reducing failures to appear. And as we were looking at different ideas, one of the things that our public defender said is, look, you can't ask people to give email addresses and phone numbers to magistrates or law enforcement officers or judges. They're not going to do it. They don't trust you people, which, you know, is a point well taken. So we, what we did is we created a separate sort of essentially process and form at booking that once the public defender was appointed by the magistrate at the time of their initial appearance immediately after arrest, the defendant could voluntarily provide confidentially their contact information, email address and or phone number that would then be confidentially provided to the public defender's office so that it could be given to the assigned attorney who could, and they could check a box, yes, enroll me in court notifications or not. And then that way the attorney would get immediately that good contact information. And if they wanted to enroll, then the attorney's office could facilitate the enrollment.
I really appreciate that. And I think one of the things that we're seeing is that automated court reminder systems are amazing. And Ideas 42 has also done a lot of work related to what those notifications should say. There's some research about how including some information can actually make the notification even more effective. But what we're seeing is that automated court reminder systems are sometimes best used when they are universal, when they are offered early. So Judge Trosh, that's right, like at initial appearance as early as possible, and often by public defenders. So I know in Lake County, it's the public defender's office that runs their automated court reminder system, and we're seeing success of those kind of court reminder systems outside of the public defender's office as well. What is true, though, is that, and I think Judge Trosh brought this up, is that folks have to know that it exists, that there has to be a process that flows people into that automated court reminders, structurally flows them into it, and that it happens as early as possible. And that then we're thinking for folks that don't have a cell phone to get email or to get text notifications, how then are we also helping them be able to get notifications as well? Because Judge Trosh, you're right. Like I get notifications for the dentist, for my hair appointments. You know, I almost missed a doctor's appointment the other day because I didn't have it on my calendar. And if it weren't for the text I got, I might not have shown up. And I think that those are really important and easier strategies. They have a cost, but I think your point is well heard, Judge Trosh, that the upfront costs might be worth it for all what you're avoiding on the back end as well. One of the other things that kind of comes up for me as part of this is this idea of even thinking about who and under what conditions can we even get bench warrants. And so, you know, we've talked about thinking about, are there some cases where a bench warrant would even be appropriate? One of the, and recent research that JSP has been doing in a site out west, we found that 40% of bench warrants came from cases that originally came in through citation. So that is that we did not believe that the behavior was worth jailing, and we did not jail them. It was not a custodial arrest, but that we have now started to jail them because they're not appearing. And so I wonder, for Judge Trosh, like, what is your response, knowing that you did your own diagnostic response of understanding people were actually being really successful in coming in, but for you hearing something like that 40% of bench warrants are actually for cases that originally come in through citation, like, how do you respond, or kind of what is the commentary to a jurisdiction like that?
That's what I found as well when I did our local case review, is that a huge percentage of those warrants or orders, we call them orders for arrest, went out on cases that started as a citation or a summons. And interestingly, of those that were served with the order for arrest, about 50% of those cases were dismissed by the prosecutor when their case came on for first appearance to review their conditions of release. So, but doing our own, frankly, we just did a 1 month case review, but doing that 1 month case review and presenting those findings to the judicial officers responsible for presiding over those types of cases in those courtrooms, to the lead prosecutors and public defenders and the clerks, was really, really helpful in moving and really developing some strategies to reduce our over-reliance on orders for arrest as a response for failure to appear. Because I think we all saw that an order for arrest for failure to appear on a case for which initiated as a citation or a summons was an over response, and that we could and should consider an alternative, like resetting the case for another date and issuing a notice of hearing to the defendant for that new court date. Another option, particularly for traffic matters that are classified as misdemeanor offenses, might be simply entering a failure to appear without a new hearing and without an order for arrest. Because in North Carolina, that failure to appear alone is going to result in a DMV notification that if you don't address it within a certain amount of time, you could face a license suspension, and people will typically take care of their traffic matter pretty quickly when they receive that notification, which they can do in North Carolina through waiver processes. So there are options, but just doing that review, seeing what was happening in our own jurisdiction, use it. And we didn't have at that time, because this was back in 2017. We didn't have some of the national studies that you're now presenting and to show us what was going on. Helped us come together and collaboratively develop some alternatives.
I appreciate that. And I think that what I heard you also saying is, like, there are other things we can be doing, and that this is really an over response. And so, I think one of the things that we want to start seeing courts collaboratively doing is some diagnostic testing. Okay, what is happening with our bench warrants? Who are getting these bench warrants, under what conditions? Are they people who are actually more often successfully appearing? Are they coming in through citation or summons originally? And these are then bench warrants then are an over response to those folks. And in the case out west, that's 40%. I'm hearing Judge Trosh say that was also a large majority. I think really dialing it back and saying there's something else. And Judge Trosh, I think you've offered here the something else then is resetting the case and sending a notification. The something else could in fact also be a citation in lieu of arrest that also gets a fresh court date, or a summons process of some kind. And I wonder for others, Mono, are there other are there other strategies that you feel would be appropriate before bench warrant that Judge Tross hasn't described?
Sure. And by the way, but no. So actually, the
sorry,
second
Manal.
syllable. No worries, no worries. Well, one thing is, I think before we get to this solutions, I think I'd be remiss to not mention the racial disparities in terms of, we know that police have they can tell someone, hey, you got this bench warrant. I know it's just a traffic situation. You should go clear it up. Versus not. The Arnold Ventures did a study and looking at St. Louis and Louisville over a certain period of time, and found that it was like 4-1 versus 3-1 when they're pulling over someone who's black versus white, and the decision to arrest versus just inform them that the bench warrant was outstanding. So we should be mindful of those racial disparities. But I think what some of the suggestions you mentioned earlier, just these days to clear bench warrants, and have those days, those open days, or have us, mobile courts where you have judges out in the community and saying, this is going to be, we're going to clear some of these warrants out here and get this done. I know it's been hanging over your head, but you're aware of it, but this is a free day. Come in, and more times where we can have instances like that, which would actually engender a little more trust of the system. And similarly, I mean, back to what you said earlier, if it was more citations, because people are going to be less likely to show up, or they're going to make themselves suspicious if they know the bench warrant's already been issued. If they know there's going to be an opportunity to come in and clear it up, much more likely to either on their own or take advantage of that, so we can get the case moving in a positive direction again. So I think just the more solutions we have like that, but for that we have to change the narrative to begin with. I saw someone really recently referred to, all these people were arrested that were fugitives. They were fugitives. They're just people who had literally using that language. We did this mass arrest of you. They're not fugitives. I mean, they're here. They're in this. If they were fugitives, they wouldn't be here, right? They're within like literally 6 blocks of the courthouse sometimes. So.
One other thing that I hear our assistant public defenders now arguing, as we've tried to really shift toward at least scrutinizing the failure to appear and making a more intentional decision about what the response should be after, frankly, evaluating, was the state ready? Should this case even move forward? And, and be continued past this date. Is our public defender's office is now even arguing, give me a chance to get my investigator to see if they can find or get in touch with this guy. Give me a chance to see what I can do to get in contact with my client and get my client engaged and in court.
Can I jump in like real quick? Let's also think about deflection first, right? I actually think I said diversion first. So I meant deflection first and then diversion. For Illinois, we would say deflection is when you don't even bring the case into the courthouse. I'm really proud that we just hired a deflection coordinator who is going to work with police departments to, I think, move into, and maybe this is very big in other jurisdictions. It's not big in Lake County, Illinois yet. But we have got to be talking about, did we even need to make the custodial arrest and give it a court referral if we just are headed towards some treatment, and mental health issues. Obviously, mental health issues and substance abuse as public health issues are obviously the way to look at many of these things. So deflect first, then divert first, or divert second, which is hopefully fewer court dates. Now, I would say to my defense attorney friends, you got to get into diversion. You got to get into like moving fast on your own case and thinking about the 50-50 Fourth Amendment issue, and public defender can disagree with me. Thinking about that 50-50 public defender issue, that 50-50 Fourth Amendment issue, when I could just go do a cognitive behavioral intervention for 6 hours on a misdemeanor, 50-50 Fourth Amendment issue, or 6 hours CBI. I leave that to my defense attorney, friends. But diversion is also a way to clear court calls and to not even risk an FTA. And by the way, you can do diversion. I have my new diversion coordinator sitting to my left. You can do diversion outside of the courtroom, right? You don't need a judge to do diversion. And frankly, you could dismiss a case out from under a judge. Sorry, judge. You could dismiss a case out from under a judge, and my diversion coordinator can still meet with a client, can still meet with somebody, and we're not even talking about FTA. So deflection, diversion, and the last thing I wanted to say is folks, if you can talk to your court administrators about combining cases, like we do have that in Illinois. I'm very proud of that in Lake County. Everybody's going to, you got an armed robbery, your DUI gets brought into your armed robbery, right? As does your misdemeanor, whatever. And these all things are all handled in one place. We can't have people, missing court on their trespassing, but they did show up to court on their DUI. Like that you got to combine everything. Like I think that's the way of the future. And then the last point is, I think this is, as we see what's going on in Washington, as we see what is no doubt racist policies regarding what we see from immigration enforcement and really difficult problems. In Illinois, we have the Trust Act, which is where law enforcement does not affirmatively call other agencies if that's the only issue is citizenship status. The more people who are getting FTA warrants, the more those practices can impact people who just have simple misdemeanors who were never going to be inside of a jail anyway, because we were going to have a different reaction to the case from the criminal justice perspective. So I think this is an incredibly important time to be thinking about how to limit FTA warrants in a truly equitable and just way, to make sure that that people are not facing what we're seeing coming out of Washington. I'll say it. I'll be the one to say it.
We appreciate that, because I think that's the reality, that showing up for court in a 2025 world, particularly for immigrants, means something different than it did just a few months ago. And so how do we assure them the safety that they need to get to court without also creating additional problems for them, particularly if they're bringing their support networks to court with them, which could also result in kind of, detention of potentially family members for them showing up to court. And so I think these are things that I think, I appreciate you naming the very large elephant in the room, because that is a reality for many jurisdictions. It's a reality here in Texas, particularly along the border. It's a reality in migrant communities. And it's a reality in places where we're seeing very large Hispanic or monolingual communities. And it's something that we have to kind of grapple with as we're thinking more about this. And so, I appreciate all of kind of what you've all said. I've heard, that we're talking about doing early enrollment for automated court reminder systems as early as possible. Before that, even thinking about deflection, thinking about diversion. I've heard strategies that are about, how do we even think about the total cases that are necessary? Do we even need all of those cases that are necessary? I've also heard, talking about Judge Trosh offering, like, at what point are we even understanding the posture of the case? Is this even appropriate for us to be issuing a bench warrant given what is happening with other actors? Or even I heard Judge Trosh saying, critically examining whether or not we should be even issuing a bench warrant commiserate with how this came in. Should we be issuing bench warrants for misdemeanors or citation or summons, right? Like, is that even an appropriate thing for us to be doing, particularly when those folks tend to be even more under-resourced, right? And then I've heard, Elaine say a bit more about using scheduling orders, thinking about the backlog of cases, really doing some strict, diagnostic work here. All of this is pretty no to low cost. But I think, Judge Trosh has pointed out, it did take time, and it did take effort, and it took intentionality, and really thinking about what does that mean? And are we willing to kind of spend the time to clear some of this up and really be more thoughtful, which again is perhaps a sunk cost, so to speak, but in the end is probably really where we want to see us. So I appreciate all of you guys all naming kind of what's coming up for folks and what you think can really be done on this issue. We've gotten a few questions, and I've seen that Judge Trosh was able to handle a few of them. And just to kind of reiterate to folks, Kevin had asked, if people come in through cite or summons, is there a way to get them enrolled in a court reminder system? And I'm hearing, Judge Trosh say that hasn't been possible perhaps in Mecklenburg, but maybe is possible in other places. So I'm wondering, for others in the room, have you seen places where we're seeing folks that come in through cite and summons get enrolled in automated court reminders or get enrolled in other reminder programs?
That's a really good question, because I actually did agree with the point about turning over the information to the government when it really can come in through a public defender's office. We know some people take, not because of the fault of the public defender's office, we know you're not going to get your public defender until you get into a courtroom, at least in Illinois. I think that's a really good question, Kevin, about what police can do from the perspective of automated court reminders, because it would be on our law enforcement partners.
Yeah, and I'll share with you that when we were trying to work through that, our public defender really strenuously argued against a practice that would encourage seeking cell phone numbers from defendants on the side of the road when issuing a citation, because he really just didn't want to create a practice where there was an expectation that law enforcement would now have this cache of personal information that could be used at some other point in time for surveillance or investigation.
Mhm. Yeah, I mean, I think those are things we have to kind of grapple with. And what does this mean? How do we help people? But I think those are important questions as we're thinking about helping people get to court. One of the other questions that has come in for Elaine in particular is, the idea that some of these online systems for folks are hard to navigate and it's really unclear, maybe like when I'm coming or when I'm supposed to be coming. And so the question for you was, do you have suggestions or have you seen ways in which courts have implemented a clear way for defendants to know what court appearances they have and whether they're required to attend them?
The short answer, unfortunately, is no. And I think that's part of the problem, right? Different states, different counties will use different terminology, none of which is written for a lay audience. And so I think it really comes down to working with your public defender or your defense attorney to identify which of those that you are legally required to attend. But I think it's a really important point as we talk about the role that courts play in this. Is there a way to standardize and a way to make a public facing system that is clear for defendants on what is happening at that event and whether or not they need to be there?
I think to that end is, another question that came in is too long away? Is there a time that's too long, right? Is there a sweet spot of when the next hearing should be? And so any thoughts on that too?
Yeah, I mean, this is a question that is currently being looked at right now. We just started a research study with the SJC Research Consortium around case processing and the impact of scheduling orders. But there's a lot of variation that plays into this, right? So courts can be under a master docket where events are scheduled with the next available judge. And then there are other systems where once a case is assigned to a judge, it stays with that judge. There's also lots of variation within a court. I will say, it won't come as any shock, but many judges treat their courtroom as their kingdom. And they schedule based on their preferences, their practice, and there's not uniformity. Where you have strong presiding judges that can set rules for the court, having a case management plan that delineates kind of time standards. And I don't mean time standards in the sense that every case has to be scheduled within 30 days or every reset has to be done within 30 days, but one that says, there are extenuating circumstances, but X percentage of cases should fall within this time standard. I think that's really important, but it's a very convoluted question because of the structure and the operation of courts, how judges implement and manage their dockets, and whether or not you have that ability to set rules for the judiciary.
I appreciate that. Oh, Judge Shosh, did you want to add something there?
Well, I agree with Elaine that you have to have clear, when there's a case management plan that establishes timelines and case processing rules that all of the that the judges who are assigned are following, that helps everyone understand what to expect and what their responsibilities are. Also, I think that defense attorneys can play a really big role in helping to communicate with their clients about which hearings they need to attend and which hearings they do not. But of course, that necessitates being in contact and having good contact information for their clients, and having an established case management plan with rules and expectations for what is supposed to happen and who is supposed to be present at particular types of court settings.
Yeah, I appreciate that. I feel like, at the end, I'm happy to hear that, Elaine, that there is work that you're doing, actively doing, about understanding, is there a sweet spot? How can we do this? I think it brings us back to this idea of leveraging the public defender and the trust and relationship that they have already built to help us get some of this done. One of the other last questions before I kind of turn it over for y'all to give your last words is that folks are suggesting that in their jurisdictions or in the research that they're doing, that they're seeing a lot of bench warrants happening because folks are not appearing effectively for their first appearance, that there is perhaps a pre-arraignment release, and that then folks don't come to kind of this initial appearance or this arraignment hearing. And it's there in which we're seeing a breakdown. And so this is really for anyone. Are we seeing this in your jurisdictions? Are we thinking more about how we make sure that people get to the first one, because that sets the pace and that sets the tone for the remainder of what the court can expect?
That's a really vulnerable period, right? Because Minot and his team may not know anything about the defendant. They don't even have somebody to check back at the office to be like, oh, are they sitting in the lobby? Right. I mean, so that's a very dangerous time in terms of unnecessary warrants. I think that is on the prosecutors, right? There may not even be a defense attorney who steps up in that moment, and so that's really on the prosecutors. We have a policy to not request the warrant unless they feel that there's some danger to the community. But how much information do we even have? Obviously, this is a non-detained person, so
Sure.
we're already hopefully a less dangerous situation. But it is, you have to. That's going to be on the prosecutors to really think about what is necessary and to think about the costs. And it's on our team to be training people to think about the costs and risks. One thing we haven't talked about is law enforcement finds the execution of the warrants or the walking up to the car at 2 a.m. when they find that the passenger has an FTA warrant. These are some of the most dangerous times for law enforcement, right? And it's some of the most unnecessary incarceration, as Judge Trosh said. That's some of the most unnecessary incarceration we could have, is where, let's say, a retail theft would never have any incarceration tied to it whatsoever if everything went according to plan. But because of an FTA and because of an FTA, you might have incarceration tied to a first-time retail theft. That's really unnecessary incarceration. And then you have a law enforcement moment where, well, I didn't have to talk to that passenger at all. I was going to give a speeding ticket to the driver. Now I got to talk to the passenger. And so this is really dangerous stuff. And prosecutors are supposed to be thinking about that when they ask for that warrant, that there can be unintended consequences for some of these. So that's something that I think prosecutors need to do a better job of training their newer attorneys who are probably in these first appearance courts about thinking about the full range of possibilities.
I appreciate that. And we know that there is work being done in SJC and Pima County, which is Tucson, Arizona, that's really about staging peer navigators at release or at pre-arraignment release to help folks get to that first appearance, get them, get them clothes, get them a shower, get them water, get them situated, get their nervous system calm, and then say, okay, this is how this is when your your arraignment docket is at 2 p.m. Let's figure out how we're going to make sure you get back here because you've been released at 4 o'clock in the morning in the middle of the, in the middle of the night, so to speak. But I think these are the issues. These are the pressing issues. And I think thinking about when, under what conditions should we be using bench warrants, if we should be using them at all, and then understanding that they should absolutely be the last resort and reserved for very, very narrow situations. I wonder, for each of you, we have a few minutes left before I kick it back to Kimberly to kind of put a little bow on our time today. But, Judge Trosh, do you have any last words or thoughts for folks kind of as they're thinking about this information and kind of going back to their jurisdictions to talk more about it?
I guess I would think in terms of two areas. One is, what can we do on the front end to remove barriers to court appearance and to increase court appearances? What can we identify the things that maybe are making it harder for people than it has to be within our jurisdiction, and what can we do to remove those barriers and facilitate better appearance rates? And then I think the second part is, what could we do differently to narrowly tailor orders for arrest for failure to appear to those situations for which that really is a necessary tool to get someone that we're really, really worried about and that we really can't find another way to engage in a case that is moving forward with witnesses ready, the state ready, and we would just really need to get this defendant engaged and present, and we've exhausted all other tools.
Yeah, I appreciate that. Elaine, thoughts or any last words for folks as they're diagnosing or thinking about backlogs or anything else?
Yeah, I just think that, the issue of FTAs is one that is not typically thought about from a court perspective. Not, present company excluded, Judge Trosh, because it is an easy response. But I think the way that we operate our courts necessarily sets up some barriers. And, even though the adoption of scheduling orders, or someone asked the question or was embedded in one of the questions about resets that happen, hours or minutes before the actual hearing, continuance policies, if there's going to be a continuance, require 24-hour notice. Those kinds of things are easy to do in theory, but they often require a cultural change among the judiciary. And I think, that is the hard part. So when you have prosecutors like Eric and public defenders like Mano who support this work, leveraging their support with the judiciary can be very important for trying to reduce court-driven barriers that create FTAs.
I appreciate that. And the conversation that we've kind of manufactured our own problem here based upon the policies, I think is well heard. Mano, any last thoughts?
Sure. I think a lot of this is culture shifting, as everyone's pointed out, and I think the big issue of deflection is huge. There's a lot of cases that don't need to be in our system. We're seeing unlawful lodging. We're seeing loitering with the intent to commit a drug offense. We're seeing some real, frankly, garbage filed in my county here in San Francisco, and I think there's a lot of places around the country where that's the same. So reducing the overall footprint in cases here, but also, it's years ago that there's a lot of people around the country who took a knee with the George Floyd killing, and we were sort of aware of the dramatic brutality of the system sometimes. And when I took a knee, I said we should be looking at every aspect of the system, because there's a brutality in a lot of places. And that bench warrant, I mean, it may be easy, but for that child who is in the back seat of a car when someone's pulled over and they have a bench warrant, that's a traumatic and potential really explosive violent situation. So to think on the back end of what that actually looks like when you just say that where it's bench warrant issued, it's not minor. in addition to the other impact, which we already talked about, which is when someone's in custody, we know pleas happen that have nothing to do, and that can have an impact on not just the next couple of months, that could have an impact on the next generation in terms of your ability to secure employment, in terms of your length and period of incarceration, and not just again for that individual, but for their whole family in the next generation. So some real thought into how we shrink the use of bench warrants is really, really vital from a humanistic point of view. So for that reason, I just appreciate all the thoughts in this space here.
I appreciate that. And last words from you, Eric.
I think I love what everybody had to say. I think thinking about why we do things, always encouraging all of our, all the actors in the system, from law enforcement to the courts and everybody in between, and that does include obviously prosecutors, defense attorneys, pretrial monitoring officers. About, are we just doing things because we've always done it that way, or is there a real intentionality behind it? I mean, do we really think a guy needs to spend 7 days in jail for retail theft when we never would have made that offer at the front end of the case? And so just thinking about what are we intentionally doing here and thinking about unintended consequences, I think is so important. And I know it's a new idea, but I'll still put it in my closing comments. I think purges of old FTAs are really important. I think thinking about those arrests, more tragic than a guy doing 7 days on a 2025 retail theft that he never would have done is a guy doing 8 days on a retail theft from 2009. That means he hasn't been into the system since 2009. So we have to actually go affirmatively. We have to affirmatively go purge old warrants. And by the way, that doesn't have to be an FTA warrant, right? You could have an 09, what we would call an information warrant, just an arrest warrant issued in 09 for a retail theft. We need to go affirmatively purge old warrants to end unnecessary incarceration and these potential law enforcement encounters, and frankly, to clear up our docket, because great judges, great prosecutors can all agree that the 09 guy should be released the second he sees a courtroom. But why is that in a courtroom to begin with, right? We could release that guy right away. Fantastic moment. But it's from 09. And that is going to take up judicial resources. And so that's a new idea. I'm not supposed to introduce new ideas in closing. I apologize.
I appreciate you. Well, thank you all so much for your time and your thoughts. I mean, I think you've all said the thing out loud, is that we have disregarded bench warrants as a tool that is truly impacting people and their families on deep levels. And now is the time to be critically reconsidering why and under what conditions we should be using, if at all. And so I appreciate that. With that, I'm going to turn it back to Kimberly to kind of give us a bow and give folks just a few last comments here.
Awesome. Thank you so much, everybody, for your participation in the chat, for your questions, for your comments. Thank you to our wonderful panelists for their thoughtfulness and their intentionality in the way that they are talking about this dynamic, how it impacts the defendants that are experiencing it, their families, and the folks that are, expected to enact these things. There's a lot of centering humanity in the conversation that we had today. So I appreciate everybody for hopping in. Just some last things as we close out. We're going to be sending out a survey. We want to hear your thoughts on this conversation, how you feel like it went, things that you wanted to see, things that you really appreciated hearing. Additionally, Shannon just dropped it in the chat. We have developed a resource to accompany this conversation that is kind of breaking it down a little bit more about challenging the use of bench warrants. And so that's in the chat. We will also send it out via email. As a follow-up, we'll send the resource, we'll send today's recording and some additional resources kind of talking about how we can infuse equity in the pretrial space. And so we hope that you will stay tuned for that. Also stay tuned for another virtual event to come soon. We'll send out some more information about that, but wanting to continue the conversation about enhancing fairness when we're thinking about these practices that we're using in pretrial. So just want to say thank you again for everybody's participation, your questions, your thoughtfulness, to our panelists, to Shannon, and enjoy the rest of your day. Thanks, everybody. Take care.